public mediator, as well as the academic director at the Strathmore School of Law. She's part of the movement, or rather the journey making the future of our law space within Kenya, and also redefining how we resolve conflicts. Apart from that, she's also a mentor, and her mentorship activities have seen her win accolades. Currently, she was recognized among the top women in academia in the recent legal awards, Nairobi Legal Awards, I believe. And currently, she's ensuring that this space, particularly on matters of mediation, is attended to. She's also very moving into matters of research, something that has seen her move from Nairobi to international podiums. Ladies and gentlemen, Dr. Melissa Mwinde.
Thank you very much. It's interesting listening to my CV being read out. So just to add to what you've already said, I'm also the director of the Strathmore Dispute Resolution Center. And as part of that, what I do is train mediators. And so that's why it's so exciting to get to talk about mediation today. Thank you.
And today we also have a live audience, and we have to recognize them, and they're going to be part of this conversation later on as we walk into the topic of the day. And I'm going to jump right into it, Daktari.
Yeah.
What is the common misconception about mediation?
Okay. So even before I move into misconceptions, let me start by defining what it is. Yeah. So mediation, it's a form of alternative dispute resolution where, alternative dispute resolution is about resolving matters outside of the court, basically outside or beyond litigation. And mediation is one of the forms, yeah? And it is facilitated negotiations. So in principle, as two individuals, if you have a conflict or a dispute, you can discuss between the two of you and come to an agreement. However, if you're unable to come to an agreement, then you can bring on board a third party who, in this case, can be a mediator. There can be different types of third parties, but for now, I'll focus on mediators. So then the mediator, their role is to facilitate the negotiations. So they're not a decision maker, not in the same way like a judge, but then they guide the parties through the process of coming up with their own solution, and that's how it is facilitated negotiation. Now, in terms of misconceptions, even understanding what mediation is as a distinct ADR mechanism, because you see there are several. Mediation is not arbitration. So within arbitration, you have, it's sort of like having a private judge. That's a very loose definition. The law books won't define it that way. But with arbitration, the third party makes the decision on behalf of the parties, the disputing parties, in the same way that a judge does. Now, parties who walk into mediation, if they don't understand what it's about, they may be looking to the mediator to tell them what the outcome should be, or to tell them what their rights are within, But then mediation is different. Mediation focuses more on the interests of the parties. Let me explain the difference between interests and rights or positions. Yeah. So the positions are basically what the parties say that they want, but then the interests are what lie beneath those positions. Let me give an example in a story. Yeah. If, for example, I had an orange here and I wanted to divide it between the two of us, what would be the easiest way of dividing the orange? Or how can we go about it?
Cutting it in half.
We can cut it in half, yeah? So arguably, that would be a win-win situation. But then if we ask the question as to why each of us wants the orange, then that may be determined differently. For example, if I asked you why you want the orange, and I'm going to put words into your mouth and decide why you want it. So let's say you want it so that then you can make juice. Yeah, so, and then I want the orange so that I can bake a cake. Because, you know, if you like grate the orange peels, it gives a nice flavor to whatever you're baking. So if we looked at it that way, looked at the why, then how we would divide the orange then would be different. So it's not just a situation of dividing it in half. Now, when we look at the interests, now that is the why, we can move into a realm of creative problem solving, because we can divide it in a way that I take 100% of the peels and you take 100% of the inside, so that then you make your juice. And that way we have a true win-win. Now, mediation allows parties to get to that space where you can move into the why, you can move into a discussion on interests, not just trying to find ways, the middle point to cut the orange. And I guess that is one of the things that can be looked at as a misconception, understanding how mediation works. Yeah.
And why mediation? Why would I option to look at it as a means of going through rather than going through the normal court systems?
Okay, so there are several reasons. One, mediation tends to be faster. Whether it is private mediation or court annex mediation, let me unpack what I mean by court annex mediation. So as disputing parties, you can look for a private mediator and, just resolve your dispute in that way. But even where a matter is filed before the courts can screen, and if they find that the matter is viable or suitable for mediation, then it would be referred in that direction. And then the parties would have 60 days, or rather the mediator would have 60 days within which to help the parties resolve the dispute. And unless there's unforeseen circumstances or extenuating circumstances that need an extension, then it can be extended for an extra 10 days. But see, we're talking about 2 months or slightly beyond 2 months. That's for court annex mediation. Private mediation, similar timelines, although that one there's no, hard and fast rule. So it tends to be faster. Litigation, you may find you're in court for years and years on end. Yeah. Another reason is confidentiality. So that's one of the important principles of mediation. Whatever is discussed within the mediation room remains there. The mediator cannot thereafter go and disclose and say, in this matter, this is how things were decided. There's no precedent. In other words, you see, like the way for court cases, if you want to find out what was decided in a matter, you can go to kenyalaw.org and look at the cases that are there. There's no such thing for mediation. So there's some level of privacy and confidentiality. So if you want your matters to remain more in-house, then that's more suitable. And then also preserving relationships, because now we are moving within the realm of interest and more discussion-based. It's very consensual rather than adversarial. Within mediation, it's not a fight as to whose rights matter more, or who should take half of the orange, but then it's a more consensual decision-making process. And because of that, it then becomes very suitable for issues where you need to preserve the relationship. For example, family matters, things to do with neighbors, employment-related disputes, where you want to focus on the ongoing relationship, then mediation would be helpful. And those are just but some of them.
Well,
it's also flexible.
Another one.
It's not as formal as court. You wouldn't be calling the mediator your honor and other such titles. You can be on first name basis. The structure itself although there's some level of structure, it's very flexible. The parties can be the ones to even speak into when the meetings will be held, where, who the mediator will be. For court, you can't choose your judge, but for mediator, you can choose. If you want to work with a particular person, you can decide either to appoint them directly or to approach a mediation body, such as the Strathmore Dispute Resolution Center, to appoint a mediator on your behalf. So there's that level of flexibility, party autonomy, where the parties speak into the decision making, which you wouldn't find within litigation.
You've talked of all these advantages. I've noted 4.
Yes.
But mediation is actually more than just a process. It's something that has a constitutional backing.
Yes.
I'm curious, how does Article 159 change the game in mediation?
Okay. So, Article 159 2C talks about mediation, arbitration, reconciliation, traditional dispute resolution, TDRMs, yeah? And how the courts should promote that. But truth be told, mediation existed since time immemorial. If we think back, even in terms of how disputes were resolved by elders within different communities, it had traces of mediation, not in the way that you'll find it happening now within boardrooms and other such forums, but mediation is one of those things that existed since time immemorial. So if you ask me, in as much as, yes, the Constitution now has come in to give recognition to mediation and other ADR mechanisms, to some extent, it's like we're going back to our roots. We are rediscovering the mechanisms that were there before litigation came in and became the norm. So, so let me just put that as a disclaimer. With that said, now post 2010, now that it's expressly mentioned in the Constitution, there has been more of a drive to normalize it, such that then it becomes it's now, I don't know, it's been embraced more. In as much as some people, especially my fellow colleagues in the profession, some of them view it as a form of accelerated decline in revenue rather than alternative dispute resolution. It still, has taken more prominence now that it is officially it's mandated or recognized by the Constitution. And that's how now even things like court annex mediation have come up. And now we even have a dispute resolution bill that is currently being discussed. And that impetus would not have happened, I think, if it hadn't been within the Constitution. So there is value in the fact that the 2010 Constitution has given recognition to mediation, arbitration, and other ADR mechanisms.
Well put, Daktari. You've put out matters that draw some persons within our audience who are upcoming lawyers.
Yes.
But I want to know, who qualifies to be a mediator? You are an advocate. You have quite the CV.
Yes.
Do I have to come to your level to be able to be a mediator?
No, anyone can be a mediator. Let me start with the disclaimer that we are all mediators in one way or another. In your home, you've probably mediated a dispute with your siblings. If you're a parent, you have quote unquote mediated a dispute with your children. So to that extent, we do have the raw material for mediation skills. But then to become a professional mediator, all you then need to do is to upskill. So it's to take those skills that you already have on active listening, on empathy, on just communication skills, and then upskill and package them in a certain way so that then you can become a professional mediator. Anyone can become a professional mediator. And what is required is to take up training. The base is a 40-hour mediation training. So 40 hours is 5 days, give or take, and then there's an assessment. Now, with that said, once you do the 40-hour training, you can then go out and be a private, you can do private mediation. But if you want to do court annex mediation, I had alluded to that earlier on, then there's a process that you need to go undergo for accreditation through the Mediation Accreditation Committee. That's a committee that maintains a list of mediators who can take up matters under court annex mediation. So if that is something that you want to do beyond just doing the base level training, then you need to apply to the Mediation Accreditation Committee. There's a bit of paperwork that is done there and vetting. And then you can then do both private mediation and court annex mediation. But to answer your question, the long and short of it is anyone can be a mediator.
Anyone, quite a wide range. But I'm also curious, now with that extension out there,
Yeah.
you have the experience, you've
Yes.
done the research.
Yes.
What separates a good mediator from a great one?
Okay. Now, that's an interesting question, because even though I've said anyone can be a mediator, I think then there's a bit of a gap in terms of regulation to then make sure that the standards are maintained to a certain level. So you do find that with different bodies, like for example, if you train under Strathmore Dispute Resolution Center, you would be required to adhere to our code of conduct. And if you're now mediating through court annex mediation, you need to apply to the code of conduct and MAC, Mediation Accreditation Committee. Okay, so what makes the difference between a good mediator and a great mediator?
Yes.
One is competence. So as I said, anyone can mediate. I mean, even right now, even without training, if there was a dispute happening, you can sit in and listen in and try and guide the negotiations. But without the training, without that level of competence, there may be some gaps. So there is great value in being trained by a good institution, and then also doing continuous professional development, so that then you keep up to speed with the discussions that are happening. Like for example, right now, one of the things that is big is online dispute resolution and AI influence within mediation, etc. Then another thing is adhering to the required ethical standards, so that then confidentiality, as I mentioned, is very key. So ensuring that even as you're practicing as a mediator, the things that you are trained to do, you adhere to. Confidentiality, impartiality. If there's a conflict of interest, that you disclose it. Because in as much as a mediator may be referred to as a neutral third party, sometimes the parties want someone who they are familiar with. Think of it within an employment context. So it's at the workplace, and maybe a dispute has arisen, and the workers want someone who they know won't take their stories out there. So they may choose to have a mediator who's a colleague or someone within the HR office. So you see, in that sense, the person isn't 100% neutral, in that they're already familiar with the parties. But then if you're only familiar with one party, you need to disclose, so that then you don't find yourself in a situation where there are perceptions of bias, which then may make the parties question your impartiality. So the long and short of it is, what would make a great mediator is someone who's competent, and then also one who adheres to the ethical standards that are required.
Okay, and maybe I'd also want to know the agreements or the results of this mediation are things that are legally binding.
Yes.
Are there missteps that can happen, particularly for you as a mediator, that may make these arrivals not legally enforceable?
Okay. So, in fact, it's good you've brought up about it being enforceable. There's another principle that at this point would be important for me to talk about, of the way within the mediation, whatever is discussed is non-binding. So if parties come up with different options, different solutions within the mediation, everything that is discussed is not binding. It only becomes binding upon the parties when there's a final agreement that is reduced into writing and signed by everyone. Then at that point, it is binding in the same way as a contract. Yeah, and it can even be enforced by the court. Now, mediation, but is a great way of resolving disputes, but then not all disputes are mediatable. I might as well just put it out there. If something is in the public interest, like for example, if it's an election dispute, then there are two parties who are contesting over a particular seat, and it is unclear as to who has more votes. So in such a situation, because of the public interest element, the two parties can't sit with a mediator and decide, okay, so this is Nairobi County, and because we are not sure, maybe we divide, you take half, I take the other half. It wouldn't be allowable. So that's one example of something that wouldn't be mediatable. So even as a mediator, it's good for you to have that understanding so that even when you meet with parties, you're able to gauge on the face of it, is this a matter that is mediatable, or is it one that is suitable, or that needs to go to the court? If it is a matter to do with divorce, a mediator can't sit with a couple that's in dispute and then decide to dissolve their marriage, because that is not within the purview of mediation. That has to go to court. So if parties came to mediation and then they decided they want to dissolve their marriage and they came up with an agreement, it can't be enforced by the court because that's not something that is mediatable.
Noted, but maybe I'd want to know, if someone mediated and we decided to resolve, if that person is also quantified as a mediator. Shortly, when we come back after the break, we're going to talk on how technology has walked into the space of mediation, its benefits, or rather anything that may be coming out of it. We'll be coming back in a very short moment. Don't go too far. We'll be back in a moment.
Are you an aspiring media practitioner, a graduate, or you just want to advance your skills in television production? Then welcome to Kenyatta University, where education meets innovation. KUTV, the premier university television station in Kenya, is now offering short courses in TV studio, field technical operations, and video editing. Through these courses, you will acquire hands-on skills on camera operations, media production, lighting techniques, audiovisual editing, and sound and visual control, and how to operate key equipment in modern TV control room. Enroll today at KUTV and discover your full potential in cutting-edge TV broadcasting. Graduates of these courses will receive professional certificates. For more information, visit our offices at KUTV Studios or call us on 020-870-4252 or 020-870-4255 or SMS us on 0739-110-544. KUTV, a new experience.
Welcome back to Law Matters, particularly today as we delve on matters of mediation, getting to understand it as an alternative dispute resolution mechanism that may be beneficial to you and that maybe you need to know about. Before we took our break, Doctor, when we were looking at how virtual placements have come into the space, perhaps you can tell us about it, because even with the onset of COVID-19, it brought us to the realization that there are some matters that we may have to rethink and also re-strategize on how we execute. How has technology influenced the space of mediation?
Okay, thank you for that question. Truth be told, yes, with COVID, we now embraced doing things virtually. Even within institutions such as this one that I'm sitting at, there was online learning. So that has seeped also into the space of ADR. So now there's a possibility of having virtual mediation sessions, or what is otherwise known as online dispute resolution, which then captures beyond just mediation, because even arbitration can be done through virtual platforms. Now, it has several advantages, but then it also comes with its fair share of challenges, because now with online dispute resolution, or ODR, it brings up that convenience in that even parties who are several, kilometers, or they are far apart, can be together in that sense to, discuss whatever their conflict or their issue is. Now, some of the challenges that come up are, the usual technological challenges that may be faced even in other forums. One of the things, how do you ensure that there's confidentiality even when things are virtual? If it is an in-person mediation session, I am sitting here with the parties, and I know that they are the only ones who are present within the room. With ODR, there is the real risk or possibility of having other parties who are not, involved. They're not the disputing parties. They could be present or could get information about what is being discussed, and thus, there may be challenges in terms of confidentiality. Things may be hacked. So it may be a link that is shared, and then people who aren't authorized get access to it. So those are some of the challenges that come up. But with that said, it has been positive, because then it's opened the space up a bit more, because I can be here and one party is in America, and we can still be able to discuss whatever the dispute is and resolve it. Now, another thing that I might as well bring up is now there are also platforms that say that they can mediate the dispute without having a human person, so that then, as two disputing parties, if you feed in the data about what your issue is, then it will help you come to a solution. Sounds nice, but it does it poses challenges, because an AI bot won't have some of the soft skills that a mediator would have. Like, for example, if I'm sitting with disputing parties and they're talking, I can read into their body language, because it goes beyond just what is being said. Sometimes even what is not being said is important. The emotions that underlie what is being said. If now that is relegated to AI, then some part of it is lost. So even where AI seems to be a possibility that we could walk into, I would say that it is still important to have a human in the loop. So AI can, help to summarize documents, to, give summaries faster, but then the human element should not be removed from the process, because that's one of the things that's so fundamental to mediation.
Well, maybe I'm seeing a research you will do and be able to give those findings soon enough.
We can research with you if you're interested. Although that takes you outside journalism.
Oh my goodness, don't want to shock me in there. But I'm going to bring you back to matters of court annexed mediation.
Yes.
You touched on that.
Yes.
And we are in a space where we are seeing courts looking for alternative dispute resolution mechanisms, reducing the backlog of cases within the court system. Is the court system forcing people to go for mediation?
I like your choice of words. Because actually, when court annexed mediation began as a pilot project around 2016, there was that debate about, doesn't it then lose the voluntary aspect? Mediation is a voluntary process. The parties are the ones who decide that they want their matter resolved through mediation. Now, parties who have filed their matter in court have chosen voluntarily to have a judge listen to their matter. So to have the parties then, steered towards mediation, there's that discussion as to whether it still is voluntary. Now, I'll just answer the question. It still is voluntary because even though the case has been screened and decided, it has been determined that it's viable for mediation, the parties don't have to agree within mediation. So they can go through their motions, they can discuss all their different interests, but if they don't come to an agreement, then that is fine. Then what would happen is then the matter would then go back to court, and then the judge would decide. Court annexed mediation, with that said, has still been like really beneficial because there are so many cases which, by being steered towards mediation, are then resolved at that level, and it unlocks many things. Instead of a matter being in court for like many years, it now can be resolved within 2 months, 2.5 months. It also unlocks revenue in that instance. So yes, to some extent, parties, that voluntary aspect seems to be played around with, but it's not that the parties are fully coerced. In fact, they're not coerced, because if they go to mediation and they discuss with a mediator and they go through the motions and don't come to an agreement, then it reverts to the court. If they come to a partial agreement, because even within mediation, by the way, it doesn't mean that, let's say there were 3 issues that needed to be, or that were in dispute, and then the parties only agree on one. It doesn't mean that all is lost. Then there'd be a partial settlement agreement. So even within court annexed mediation, if there's a partial settlement agreement, then whatever was discussed within mediation, that's the done deal, that's closed. And then it will be the other matters that then go back to the court. If everything is fully resolved, then the court then would adopt that agreement by the parties as though it was decided by the court. And so in that way, the matter then is closed. So to that extent, it has helped to reduce the backlog, because many of the cases which can be resolved amicably, family disputes, commercial disputes, employment-related matters, quite a number have found themselves within the space of court annexed mediation and are closed much faster than if they remained in court.
Wonderful. Dr. Eri, you've talked about the dispute resolution bill that is still in its constructive stages.
Yes.
And I'm lucky to know that you've been able to be exposed. You moved on the international spaces.
Yes.
You've looked at various jurisdictions and what they are doing in matters of mediation in their spaces.
Yeah.
What is that necessary element that maybe is missing within our system that you think, if applied, would actually make it better?
Okay. We're already on the right track. I think things are going great. We have more and more people who are open to and are embracing alternative dispute resolution, including mediation. So to that extent, we're on the right track. However, having some form of regulation within the space would be helpful, whether it is self-regulation or more of a top-down approach, but so that then standards can be adhered to, so that it's not just, I don't know, just some way of making sure that there's vetting. You see, the same way that for court annexed mediation, there's a system. You can tell that, someone is doing the right thing because they're within the list, and in case there's any report against them, then there'd be consequences for that. Without overarching, regulation for mediation or a way of checking in that standards are being adhered to, there's a possibility of having a few quacks doing things their own way and purporting that it is mediation. And if society is not aware, then they may fall prey to that. So I would say one of the things that would be helpful, and that's why I think we're on the right track, having discussions such as this on having a dispute resolution bill is a direction that I think, we're moving in the right direction. Now, I think maybe we just need to fast track to actually get there, but we're on the right track.
Even as we think on the realms of having maybe an authority body that can be able to ensure everything is on point, I am curious, because this is something that you run a department on, you're an authority on. You also are a lawyer, so I believe you're going to answer me with the wisdom that you have, without sharing too much or concealing so much that we may not be able to attain the knowledge you're looking out for. Can you share like a case study or something that maybe a resolution or rather a mediation that you did and you saw the transformative impact that it had, that would maybe not have been there if the adoption for litigation?
Well, there you've put me in a tough spot, because remember, I had talked about confidentiality.
Yeah.
So even as you were talking, I was like rummaging through my mind to try and see what can I, reasonably talk about as an example without breaching confidentiality. And I think with that, I found an example. So there was a particular matter, and it happened to be siblings, and they were in business together. And so, I mean, life happens. And so there was a dispute. It was a commercial matter. But then the fact that the directors were siblings, to that extent, there was some familial relationship. So to just jump into it without giving too much information, the advantage of having resolved it through mediation was that it kept it outside of the court, because I think if the matter was being dealt with within the court, then all the affairs are then out there in the public. And the fact that then it was discussed within a framework that guarded that level of confidentiality then made a difference. And also that things were resolved much faster than if it had gone through court. The strain that would have been there within the relationship that then would have been felt within the business was then averted. But I haven't given you the story because I cannot.
I believe you're safe, right, lawyers? So if I'm to continue to probe and maybe bring it in terms of statement, mediation improves access to justice.
True.
Defend.
So access to justice, let's first start with what is justice. Justice, there's this conception that justice is correlated with the courtrooms, so that then access to justice is looked at through the lens of litigation. But truth be told, it is possible to access justice through various means that don't necessarily involve formal litigation, even negotiation, even just parties on their own, if they have the right skill set in terms of negotiation, can then access whatever is justice to the two of them at that level. Mediation, having a neutral third party come in and guide parties who are not seeing eye to eye, so that then they're able to find a solution. That is justice.
Well, I'm going to allow you now to maybe even make a message to the lawyers in the house who are coming in this space. One, alternative dispute resolution also has been acronymed in a different direction that you've noted.
Decline in revenue.
But obviously we are looking for ways of also economically upholding the upcoming lawyers. Maybe you want to give them why this would be an option that they would take, why they would invest the 40 hours and also be mediators apart from being advocates. Bring us to the lucrative part of, okay, how much do I make, if you are able to share that? And also why they should play into moving in this direction, particularly with their counterparts maybe giving it the acronym of extracting from where they may be focused on.
Okay, so when it's okay, I wouldn't disclose about the money part, but then
you can give us a rough.
There is money within ADR. So it is as I said, it can unlock disputes faster. So to that extent, if it was a matter that you'd have been in court, for 3 years, within 2 months, you can already, have your paycheck and move on. But if I look at it from the point of view of what is in the best interests of disputing parties, is it to have parties in court for years on end, or to have things resolved in a timely manner so that then we can preserve relationships, so that then we can have a more cohesive society? And I think if we looked at it through a different lens, what is in the best interests of disputing parties, I would say embracing ADR is a way to go. And it doesn't mean that by then taking on mediation or arbitration or other ADR mechanisms, that now the lawyers lose out. By the way, we do have many lawyers who are still involved within the ADR space, either representing clients, although I use representing very loosely because it's not in the same way that, they would speak on behalf of the clients in court, but then they still work with the parties through the journey. Like, for example, they still serve a very important role in advising their clients. So they can still be a part of the process. So either, sitting beside their clients within the mediation process, or two, if the lawyer has also, trained as a mediator, then they can wear that other hat where when they are involved in disputes, rather than pushing for matters to go to court, they can wear the hat of a mediator and then help parties resolve it at that level. So even as an advocate, you can refer your clients to mediation, and then they sort things out faster. They'll be repeat clients if they have any other issues, or recommend parties your way.
Indeed. You've talked to the lawyers. I'm imagining a family member who maybe is watching this show right now, and they are thinking of going for mediation. What is your counsel, and why is mediation something that they should consider apart from just going for litigation? Now speak to this family member who has an issue that is quite overshadowing them.
Okay, so especially for family, and I talked about one of the advantages of mediation being preserving relationships. So if it is family members, you're not going to trade your family member for another person. They're going to continue being with you. So if you're able to resolve the disputes in a way that can still have the possibility of the relationship continuing amicably, then that I think is an ideal situation. Even if it is, let's say it's neighbors who have a boundary dispute. Yeah. So if they take the matter to court, yes, you can have, someone come in and say this is where the boundary would be. But then if the parties don't own that decision making, then you'll still have a win-lose possibility. One person will still probably be feeling very upset, and within the court space would then probably want to appeal, then appeal till Supreme Court. But then if the parties are the ones who have been involved in the decision making, they own the decision, then they are likely to enforce it. And that way, if it's neighbors within they have a property dispute, they are the ones who have had the discussion and decided where the boundary should be, then they will still be saying hello to each other after that. It then won't be a continued fight. With litigation, unfortunately, most disputes end up in a win-lose situation. There's one person who, goes home feeling they are the ones who have gotten everything that they were seeking, and then the other one still feels aggrieved. And so if you're looking at it from a relational point of view, there's something that has been damaged there. So if it is siblings, if it is co-workers, if it is neighbors, if it is, anything that there's the relational aspect, mediation then can at least, ensure that as the parties are navigating their dispute, it doesn't come at the cost of ruining their relationship. Well, so it's a true win-win.
Well, that is well put, and I hope well understood. And wherever you are, if you're considering mediation, you do have the reasons on how to go about it. And if you have any questions concerning this particular topic, the numbers are on your screen, social media handles. Respond to us, give us your questions. We'll be able to break them down when we come after this short break. Also, we'll be engaging our audience right here at the Parklands Faculty of Law, and they'll be also sharing their questions to Dr. Muindi so that we can be able to break them down and ensure everyone is going home with digestible pieces. We'll be back in a moment.
Msimu mpya, uso mpya, nguvu mpya, bila shaka na ari mpya. Lakini dhamira ni ile ile. Kuboresha kilimo kwa maisha bora. Jiunge nami James Baraka na hudha wako mpya wa kipindi cha Boresha Kilimo, tunapochunguza mbinu za kisasa za kilimo, ukipenda teknolojia ibuka katika kilimo, maoni ya wataalamu na hadithi za mafanikio kutoka kila pembe ya taifa. Kutoka kwa wakulima wadogo hadi biashara za kilimo zilizostawi, tunakuvika maarifa na suluhisho kamili, si tu za kuongeza mazao yako, bali pia kuimarisha maisha yako. Kila Jumamosi saa 6:30 na Jumanne saa 4 asubuhi, usipitwe na baraka za Boresha Kilimo, nami James Baraka, hapa hapa KUTV.
Welcome back to Law Matters, the show that focuses on the fact that laws do matter and they are very important in our social construct as a people, particularly within the Democratic Republic of Kenya. And today we've been talking about mediation. And right now we are within that space where questions do fly out from the audience and also from you at home, in case you have questions about this whole discussion and also understanding the pertinent issues concerning mediation. Perhaps before we engage to the audience, I'm going to ask you, there is this terminology, the 60-day timeline. What does it mean?
So 60-day timeline is within court annex mediation, meaning that if the court refers a matter for mediation, and by the way, this may be either that the court of its own motion has decided or at the party's request, because the parties of their own accord may look and decide, okay, we came to court, but then maybe we want to consider an alternative. Now, once the matter is referred for mediation, it has to be resolved within 60 days. So basically, the mediator has 60 days to work with to get the parties towards an agreement. It doesn't mean that the mediator should force them to come to an agreement, because there's the possibility of the 60 days lapsing and there's no agreement. But if that happens, then the mediator then files a report to the court to say the parties did not agree. If there's an agreement, then the parties file the agreement with the court. But the timeline for court annex mediation is 60 days.
So 60 days.
Yes.
If we fail to agree, is there a space for us to have a continued mediation, or the 60 days is just the timeline the mediator had to just do this, or the process moves to litigation?
I mean, after 60 days, it moves back to litigation. But if the parties decide, maybe they're like, okay, maybe we didn't, give it our all. And when it goes back to the court, they look and they say, maybe mediation was better. They can request that the matter is referred to mediation again. So it's not that, after that is it. But then it does give finality to the process. And that's one of the advantages. So that then with mediation, it's not an extended timeline. It's 60 days. And if it's not resolved at that point, back to court.
And still voluntary.
Still voluntary.
Okay, now to our audience. We had questions. Kindly tell us your name and also submit your question to Dr. Muindi.
Okay, good evening.
Good evening.
My name is Andati Abuya, President Legal Aid Society. And so to you, Daktari, I'm interested to know whether ADR offers pro bono services, and if no, what is the least amount that you can charge for someone who is, okay, for the less fortunate or for the underprivileged? Thank you.
Thank you very much. Next question.
Good evening.
Good evening.
My name is Clinton Ojenge, and I would like to pose this question, but it's a kind of general question. Now we've seen that mediation applies to certain disciplines in law, and not all of them can be subjected to mediation. But there is an upcoming trend whereby, though it's under reconciliation and all that, negotiations, but criminal matters such as murder are being subjected to alternative dispute resolution. Does this mean that in the near future we may experience a situation whereby the legal system and the criminal trial system is disregarded and people opt for the ADR mechanisms, and even mediation will not be allowed to take part, for members of the public to take part in such instances? Yeah, I would like to inquire that.
Is there another question? Okay, we bring it back to you, Daktari.
Thank you.
Break them down.
Yes, thank you. I'll start with Andati's question.
Yeah, you can just even face them as you answer.
Thank you.
Yeah.
On whether mediation can be pro bono. The long and short of it is yes, it can be. Now, you find mediators charge different amounts of money, and a lot of it has to do with the years of experience that a person has, and even depending on the body that they are mediating under, you may find that there's a framework in terms of fees. But with that said, there's still the possibility of doing things pro bono. And I know many people who do that. You find, like I have a colleague in the profession, let me call her that, who opened an office near the chief, so that then when parties go to the chief to complain about the small issues that may have arisen, especially disputes within their homes and all, then they can just be told to go to the nearby office, which is hers, and then now she listens to the matters, and depending on the state that the person is in, they may be charged a very negligible fee, or it may be free. Now, with that said, yes, it can be pro bono, but sometimes there's a benefit to charging something, even if it's a small fee, because if something is given 100% for free, then it may be not valued or cheapened. So I think a better approach would be to charge based on what the person can pay, but not to give it 100% for free. But yes, it can be pro bono. I hope that has answered, yeah? And then there was the question by Clinton,
yes,
about criminal matters and mediation. Now, I had said that not all matters are suitable for mediation. And when it comes to criminal matters, that's where there's a bit of hesitancy, especially where, let's say, grave criminal matters, robbery with violence, murder, etc. It is not impossible for those matters to be subjected to ADR. It's just that with the public interest element, they may be better suited for the judiciary, for basically litigation. However, petty offenses, it can still be criminal. It can be petty theft. Can still be dealt with, very well through mediation, and all would be well. But there's still a bit of discussion as to the viability of mediation and other ADR mechanisms, because it can also be, TDRMs. You have, I don't know whether you've heard about this, but there's been cases within certain communities where a person has been murdered and they discuss it at the realm of, blood money or exchange of camels for the life that was lost. So that there's an academic debate on that. And so currently it's not that, all criminal matters 100%, ADR route, but it is a possibility that is considered. Yeah.
Answered. Well, I'm going to come back to you, Daktari. I have a question. You touched on matters of confidentiality among the benefits of this alternative dispute resolution mechanism. But I'm curious, can what perhaps I said in the mediation be used against me in court in case we don't move in the place where we had anticipated?
Now, that's an advantage then of having the lawyers within the mediation. Because of course lawyers would pick up on that. Because yes, it's shielded with confidentiality. So even what is said within the mediation, at the mediation table, should remain there. And if a party then decides to use that information, especially if there's been no agreement, to then try and use that information within the litigation space, there can be an objection that the information is not admissible because of where it was obtained from.
Even if it's factual.
Even if it's factual. Now we're moving into law of evidence on admissibility of evidence.
So why more lawyers should actually consider being part of
that then they're with their clients within the mediation, so that in case, okay, we would like for everything to be agreed 100%, but then realistically not everything will be. And in case then things have to go back to court, then the lawyers would have taken note of what cannot then be disclosed because it was discussed within the mediation space.
Okay, this is your domain and a place where you move with authority. And I believe you're trying to create a legacy of nurturing upcoming mediators.
Yes.
Speak to them before we end the show.
First of all, can I market to tell them that if you're interested, come we train you.
Proceed.
Yeah. I mean, at Strathmore Dispute Resolution Center, we train mediators, and we're one of the best. Not saying we're the only ones. There are others, but we're one of the best. But that notwithstanding, whether or not the mediation skills will be used within ADR or in other contexts, I think having mediation skills is one of the things that's very important. You don't have to become a professional mediator, in the path that I have chosen. But once you have the skill set, those are transferable skills. You'll find that it will change your perception of dealing with conflict, which is still helpful. Wherever you are, conflict is inevitable as human beings because we are different. So having the skills to navigate conflict in an amicable way won't do you any harm. So I would say anyone and everyone out there, train as a mediator, whether through us or any other institution, but those skills are paramount. They're very fundamental.
Thank you very much, Dr. Melissa Mwendi, for demystifying mediation to us. I hope you've been able to acquire data that you did not have, particularly concerning mediation, as it happens to be a humane way of being able to solve disputes that we may have within our social relationships, and also a way to escape the possible long journey of litigation. It has come to the end of our Law Matters episode for today, and I do appreciate your viewing and your engagement through this program. Also, I'd like to appreciate the studio audience that is here with us, being part of us, keeping us warm and keeping us connected into the live connection right here at the Kenyatta University Faculty of Law in Parklands, Nairobi. Also, extend gratitude to Dr. Tom Ratemo, the Dean of the Faculty of Law. We appreciate the hospitality within the Kenyatta University, the premier university that is extending out and also sharing its glory with others. As you can see, we have Doctor from Strathmore University partnering in ensuring that education moves out, knowledge is spread out, and also create that necessary knowledge that is necessary for you in understanding the law of the land, the law of the Democratic Republic of Kenya, which is relevant to you as a Kenyan citizen or one who desires to be. My name is Emmanuel Kutosi. Join us next week for another informative piece within Law Matters, where the law does matter. Thank you very much. And